Today's topic, AFAD and FIRB explained. Okay, now I'm sure you have heard the terms AFAD and FIRB being thrown around when it comes to foreign purchases in property transactions in Queensland. I know a lot of agents put it in the too hard basket and have little or no knowledge on the topics. Now, it is a difficult and a confusing area of the law. I'm going to explain to you the main things you need to know about AFAD and FIRB in Queensland without being a fuddy-duddy lawyer and overcomplicating everything. This video is a bit longer than what I normally shoot and does have a fair bit of technical information to digest. Please note this is only general advice, not legal advice, and anyone looking to purchase who may be subject to these charges should seek their own legal advice before they sign any contract. You'll walk away from this blog with the tools you need to have a baseline understanding to navigate AFAD and FIRB questions that you may encounter in your day-to-day as an agent. If you are watching the video version of this, I suggest you read or bookmark the blog, blog.empirelegal.com.au, so you can reference it for later if you need any further information. There are also a few handy links in the blog that reference certain government departments that we're going to be talking about in this video. Okay, so what is AFAD? AFAD, or Additional Foreign Acquirer Duty, is a state-based tax that applies to foreign buyers of residential property in Queensland. This tax is in addition to the standard transfer duty and is designed to ensure foreign acquirers of residential property who benefit from government services and infrastructure contribute the same as local buyers who've been paying local taxes for years. The tax rate for AFAD is currently set at 7% of the property value for foreign individuals and companies and is payable at the same time and on top of the usual transfer duty. So, you're a foreign person for AFAD purposes if you are a foreign individual, a foreign corporation, or the trustee of a foreign trust. You are a foreign individual if you are not an Australian citizen or permanent resident. So, this means every purchaser that does not have Australian citizenship or is not an Australian permanent resident will be subject to this additional tax for their share of the property. A side note on Kiwi citizens. A New Zealand citizen is generally granted a special category visa automatically upon their arrival to Australia, which then expires when they leave the country. The holder of the special category visa is treated as a permanent resident for the purposes of AFAD. So, provided they are living in Australia when they enter into the contract and hold the special category visa, they should be exempt from paying AFAD. A foreign corporation is one that is incorporated outside Australia or in which foreign persons or related persons of foreign persons have a controlling interest of at least 50%. The same applies for foreign trusts. Please note, there may be exemptions that apply, for example, the holders of retirement visas or purchases of lots in a hotel, so it's always best not to give any specific advices. Instead, just being able to identify if a purchaser may need to explore AFAD or FIRB and would need to obtain independent advice. Okay, now on to FIRB. What is FIRB? So, FIRB, or Foreign Investment Review Board, is an Australian government department that regulates foreign people purchasing property in Australia. If you are a foreign person or company looking to buy residential property in Queensland, you may need to apply to FIRB for approval before proceeding with your purchase. If you're an Australian citizen or permanent resident, or a New Zealand citizen, you do not need to apply for FIRB approval. This process is usually completed by the purchaser themselves, direct on the government's website. If they require help, we suggest engaging immigration lawyers who specialise in this area. On and from 29 of July 2022, FIRB application fees doubled. This means, for residential land of $1 million or less, $13,200 application fee, previously $6,600. Residential land for $2 million or less, $26,400 application fee. Residential land for $3 million or less, $52,800 application fee. These fees are generally payable at the time an application is lodged. For most applications, the statutory time frame of 30 days for making a decision on an application or notification will not start until the fee has been paid in full. Also, there is an annual vacancy fee for foreign owners of residential dwellings if the dwelling is not occupied or rented for at least 183 days, which is approximately 6 months in a year. Just another thing to keep under your belt. Now, an example of some exemptions from the requirement for FIRB approval are: if a foreign person is purchasing the property with an Australian citizen or permanent resident or New Zealand citizen as joint tenants and are in a spousal relationship, then they are exempt from needing FIRB approval. This exemption does not apply between friends or family members. They must also reside in the property as their principal place of residence. To be eligible for this, they must either be married or in de facto relationship. An example of a de facto relationship is that they have lived together for 2 years or longer. Please note, this is not an exhaustive definition. Another exemption available is for new or near new properties where the property developer holds a FIRB exemption certificate for the property that the foreign person would like to purchase. Overall, the cost of obtaining FIRB approval can be a significant expense for foreign buyers looking to invest in residential property in Queensland, and without it, they are legally unable to purchase the property. It's important for a buyer to factor these costs into their budget and also ensure the contract is subject to the approval being obtained and allow sufficient time for the approval. Of course, we can help with these special conditions. All right, a couple of hypothetical situations to tie this all together. Sergio's a foreign person looking to buy a $1 million residential property in Queensland. He's found a place at Indooroopilly. He'll be required to pay the standard transfer duty on the property. If he's moving in as his PPR or principal place of residence, that transfer duty would be $30,850, as well as the AFAD, remember that 7% of the purchase price of his share, which is an extra $70,000 on top. Furthermore, he will require FIRB approval, which will take approximately 30 days and attract an application fee of $13,200. It's a lot of money. All right, scenario 2. Sally is married to Fernando. Sally's Australian, however, Fernando is not an Australian citizen or permanent resident. They are looking to buy a property together for $1 million to move into as their principal place. As long as they buy as joint tenants. Now, if you remember in a prior video, I've explained joint tenants versus tenants in common. I'll pop the link in if you want to go back and brush up on that. So they're buying as joint tenants and have the property as their PPR. Fernando will not require FIRB approval because of the exemption. Fernando will, however, need to pay AFAD 7% of the purchase price on his 50% share of the $1 million, which is an extra $35,000 in addition to the normal transfer duty of $30,850. Okay, so what questions do I need to ask? The whole idea of this blog is to protect both you as the real estate agent and the agency from any risk or claim, and to be able to flag possible issues early that may prevent the transaction from actually settling. To help achieve a smooth transaction, the red flags you need to know that should prompt you to advise a buyer to seek advice from their lawyers for FIRB and AFAD are really simple. Just ask them if they're Australian citizens or permanent residents. If the answer is no, they need to speak to someone who can counsel them for their specific situation. Remember, this can also affect the lender. They will need to make sure their banker or broker knows that they are foreign too. This base knowledge can prevent a major disaster, i.e. a deal falling over because the purchaser doesn't have the right amount of funds to complete settlement or the proper approval to buy land in Queensland. It is crucial that the purchaser understands their position before signing the contract of sale. In summary, if you have a foreign person or company looking to purchase residential property in Queensland, it is likely they'll need to obtain FIRB approval first and may also be subject to AFAD taxes. It's important to carefully consider these regulations and their potential impact before proceeding with property purchases. Feel free to get in touch with us. We have a bank of precedents. We're happy to help, especially with our referral partners. Whatever you guys need to help make the deal get sorted without headaches. That's what we're here for. I've also popped some links in the resources section on the blog, things like AFAD website, FIRB website, contact numbers for Treasury, for AFAD and Office of State Revenue, pretty much every extra bit of information you're going to need that I used to build this blog and video. Thank you guys. See you on the next one.